Hello and welcome. Uh, Today we will discuss about the Hindu newspaper on 21 February 2025. Our first topic is I and B Ministry wants OTT. Okay, OTTs against obscene content. So ministry cites complaints from general public, MPs and statutory bodies direct streaming services to enforce age-based rating for mature content in accordance with 2021 IT rule. First of all, what is OTTs? Now, OTTs over the top. Okay, over the top is a means of providing television and film content over the internet at the request and to suit the requirement of the individual consumer. And the term itself stands for over the top, which implies that a content provider is going over the top of existing internet services. So it's screening content. The INB Ministry's latest advisory has issued the following directives to OTT's platform on obscene content: ensure age-based classification and enforce age gating for mature content, and avoid prohibited content, obscene, vulgar and pornographic. Okay, and follow IT rule 2021 for content moderation. Comply with laws such as POCSO Act, IT Act, Bharatiya Nyay Sanhita, okay, and large framework for OTT regulation, over the top regulations. So, indecent representation of women prohibition act, and IT Act prohibiting obscene digital content, and IT rules for streaming platforms. Last one is Bharatiya Nyay Sanhita expands content regulation. So, warning over the top OTT streaming services against transmitting any content that is prohibited by law. And the Union Information and Broadcasting INB Information and Broadcasting Ministry on Thursday said this should ensure age-based classification of content under the Information Technology Intermediary Liability and Digital Media Ethics Code Rule 2021. Okay, the OTT platform should enforce gating requirements for mature content, the ministry said in a advisory citing complaints from MPs, statutory organization and the public. Okay, so इस पर एससी का एक्शन है सुप्रीम कोर्ट का ऑन थर्सडे में. ए सुप्रीम कोर्ट बेंच लीड बाय जस्टिस सूर्यकांत orally observed that the government needed to take some action on obscene content on social media. The present advisory has only been sent to online curated content platform, the legal term for streaming platforms such as Netflix, as opposed to user generated content platforms such as YouTube. Okay, the court was hearing a case on clubbing the FIRs against Ranveer Allahabadia. Okay, the podcaster who has been at the center of a storm over a joke he cracked on the YouTube so India's Got Talent latent. Okay, not completely banned. The IT rule do not completely ban swearing, sex or nudity. They instead require that show and films that feature these along with substance abuse, the violence, and be rated for older audience. Apart from the IT rules, the advisory point to other laws to warn streaming providers against content that feature of obscenity. Attention is also invited to the provisions of Incent Representation of Women Prohibition Act 1986. Okay, Bharatiya Nyay Sanhita BNS 2023, and the Protection of Children from Sexual Offence, POCSO Act, and the Information Technology Act 2000, when publication of obscene, 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 publication of ob pornographic content is a published offense, the advisory rate. Okay, so now discuss about OTTs. The OTT advantage, with OTT video delivery technology, people now have a multitude of options at their fingertips, and they have the ability to view content on a variety of platforms such as smart TV, Roku, computers, tablets, mobile phones, or gaming consoles. They also have the option to access multiple distributors for specialized program and view channel by app switching. Okay, giving them more control over the content they choose to purchase and watch. In fact, while they both use IP technology, IPTV is delivered over private cable network compared to OTT delivered over internet services. OTT systems overcome the limitation of the single operator set top box, okay, STB, set top box technology required by IPTV. With OTT, content is only delivered upon request. Okay, each connected device has a unique connection to the source of content via the internet, making it unicast, delivering on a stream to the one device. Okay, so how does OTTs work? One of the inherent problems with serving TV uh, content over the internet is being able to contend with the wide range of network performance, and performance depends on what speed the connection will support. For example, fiber, Wi-Fi, LTE, DSL. The display device, for example, phone, is streaming device like Roku, Apple TV, or Fire Stick, okay, or laptop. And then how many networks hope there are between the provider and the end user. Okay, at a high level, OTT system and technology are designed to minimize the impact these parameters have by providing a best effort pros to serving of the content, and that is OTT technology will adjust to the network performance of the entire chain in real time, so that the video and audio are delivered without pauses caused by buffering. And these pauses are extremely frustrating for the viewer and many cause them to abandon of the content. For slower networks, it will scale down to lower bit rates. For faster networks, it will scale up to provide that the best quality. Ideally, when on a very fast network, the player will buffer additional content to get ahead, and the smooth out periods of network slowdown. It does this with a technique called ABR, which stands for adaptive bit rate streaming. Okay. Now, challenges and points of concern. Visibility of distribution quality is challenging but can be addressed with premium OTT testing and monitoring solutions. OTT services often involve multiple services providers, CDNs, and local internet, which implicates diagnostics. And quality user experience will be a key differentiator for OTT providers. Live OTT deliver is more complicated, must work across brushy, non-guaranteed internet networks, and must deliver to an endless range of devices. And concern is, how do OTT operators guarantee quality delivery and operational intelligence and diagnostics? Now, move on the next topic. Key provisions of DPDP Act infantilizes PWDS activities. Okay, so first of all, key provisions of DPDP Act. What is DPDP Act? Now, the recently introduced Digital Personal Data Protection Act 2023, DPDP Act 2023, marks a significant step towards ensuring data privacy and security. Timeline of the DPDP Act 2023, 2027, 2017, and Supreme Court recognizes the right to privacy as a fundamental right in Justice K.S. Puttaswamy, Government of India. Okay, so disability rights activists in Delhi are building a coalition to get a key provision of the Digital Personal Data Protection Act 2023 dropped or amended. Section 9 first of the act has clubbed children with person with disabilities PWDs to mandate that even in case of disabled adults who have legal guardians, consent for use of any personal data must be obtained from the guardians concerned. Disability rights expert and policy think tanks have argued that this infantilities PWDs stem from a understood notion of their guardianship and negates the decision making capacity of PWDs recognized by the rights of PWD, RPWD Act 2016 and the United Nations Convention on the Rights of Persons with Disabilities, UNCPRD. Okay, so now we will discuss about DPDP. Now, the Government of India recently notified the Digital Personal Data Protection Act 2023, DPDP Protection Act, मतलब DPDP Act 2023. India's DPDP rule 2025 aim to enhance privacy and data protection, but ambiguities like consent and third-party risk and need addressing. Data principals gain the ability to access, correct, and erase their data along with mechanism and to withdraw consent and handle complaints effectively. Now, key provisions of the Act. Applicability. The law applies to the processing of digital personal data within India where such data is first collected online or second collected offline and is digitized. Okay, it will also apply to the processing of personal data outside India if it is for offering goods or services in India. Next one, consent. Personal data may be proceeds only for a lawful purpose after obtaining the consent of the individual. A notice must be given before seeking consent. The notice should contain details about the personal data to be collected and the purpose of processing. Next one, lower age of consent. The law gives powers to the central government to prescribe a lower age of consent and than 18 years for accessing internet services without parental consent if the platform they are using can process their data in a verifiably safe manner. And this would essentially mean a white listing approach for companies in the EDH sector and for medical purposes, among the other things. And ease of cross border data flows. The center has proposed to significantly ease cross-border data flow into international jurisdiction by moving away from a whitelisting approach to a blacklisting mechanism. And earlier, the government had said that it would issue a list of countries where data flow would be allowed. An impact on social media companies. Significant data fiduciaries, the fiduciaries with huge volume and processing sensitive data, have to develop their own user verification mechanism. It will reduce the anonymity of users and decreases trolling, fake news, and cyberbullying. Okay. Now, exemption. Rights of the data principle of obligations of data fiduciaries accept data security and will not apply in specified cases. These include prevention and investigation of offense, and second one is enforcement of legal rights or claims. The central government may, by notification, exempt certain activities from the application of the Act. These include processing by government entities in the internet in the interest of the security of the state and public order. Second one is research, achieving and statistical purposes. Okay, and Data Protection Board of India. The central government will establish a Data Protection Board of India, and key functions of the board include: number one, monitoring compliance and imposing penalties. Okay, and number two, directing data fiduciaries to take necessary measures in the event of a data breach. Okay, and third one is hearing grievances made by affected persons. So board members will be appointed for 2 years and will be eligible for reappointment. Okay, now penalties. The schedule to the Act specifies penalties for various offences such as up to 200 crore for non-fulfillment of obligations for children and 250 crore for failure to take security measures to prevent data breaches. Okay, and penalties will be imposed by the board after conducting on an inquiry. सो आई होप आप लोगों को ये क्लियर हो चुका होगा आज जो हमने क्लास में कवर किया है. एंड अब हम नेक्स्ट क्लास में मिलते हैं. तब तक के लिए बाय. थैंक्स फॉर वॉचिंग.